Well, hello, everybody. Welcome. Thank you so much for being here today. I am excited. I think this is going to be pretty good for y'all. We are at precisely 10 a.m. on another beautiful day in San Diego. I've just never experienced a bad day in San Diego. It's just one of those things. Some of you remember John Coleman, who used to be, God rest his soul, used to be our weathercaster, saying that they really tape the weather 6 months in advance because it was always pretty much the same. So if you believe that, it's a good thing. In the meantime, thank you again for being here. We are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there is my telephone number, and there is my email address. Email is really good for me. So if you need to get a hold of me, please feel free. Make sure that we get that button going. Make sure my mic is on. Yes, it is. If you can't hear me, please let me know. Do something, wave your hand, do something. But I think we're good. We're 5 by 5 at this point. So, okay. So I do have some credentials that qualify me to speak about the subject matter today. And we'll talk a little bit about that. I've been in real estate for in excess of 40 years now. So I'm at that point where, and Lynn will be very excited, I don't have to pay for my license renewal anymore. So it's kind of a neat thing. I don't have to take continuing ed. It's just great. But you know, something I've had a great time. It's been a great career. And I am a broker. I have a broker's license in California. I have a broker's license in Virginia, getting a broker's license in West Virginia. There's a lot of activity around our country, and I always like to be where the hot spot is. Plus, if you have a broker's license, and now when you visit family, you get tax deductions for it. So it's all a good thing. I do teach continuing education for attorneys. I'm in the middle of that class right now, and my subject matter is real property law. And obviously, we're going to be talking a little bit about that today. I am all about risk management, as you can see from the right-hand side of your page. And next year, I'm proud to say that I will be the chair of the Legal Affairs Forum. So even more happening on that front. So that being said, we're going to be talking about some things that are going to appear to be legal. I just want you to know that I am not a practicing attorney. I have no interest whatsoever. I think they work way harder than we do, and we get paid way more money than they do. So bottom line is, I do trial work, but it's limited to testifying as an expert witness, mostly standard of care for real estate licensees, agents' duties of inspection and disclosure, and market conditions in San Diego County. So conversation today is not intended to be a substitute for the advice of your broker, nor for that of your attorney, unless you are the broker, of course, and then you should be talking to yourself. But please consult with them as appropriate. I mean, you're paying them to help you and to guide you and to provide support. So I'm sure they want to hear from you. So our webinars are intended to be interactive. Please utilize the Q&A button to ask questions or offer input. I do look forward to hearing from you. In the very beginning, when we were teaching these classes back years ago, when we got started, I got started teaching for SDAR. We discovered that a lot of times, if we allowed people to just start talking on the microphone there, once they muted themselves, it would just turn them back off, turn them back on again at the most bizarre times. So we just kind of got away from that. Although, as you probably know me, I prefer to be speaking live and in front of you, but more people can get to these webinars now because of the fact that we are offering them the way that we are. So thank you all. Very much appreciate you being here. Today, our subject matter, we're going to talk about the top 6 disclosures. And I'm going to edit that a little bit because that's changed, but it's close to 6. But we're going to go through those disclosures, and I'm going to show you what needs to be done and what needs to be said. So this afternoon, I'll be doing residential property management forms, including some forms from the California Department of Real Estate. And then on Thursday, we'll start off with how to create the zip forms template. I have a great class prepared for you for that subject matter. And then in the afternoon, then we'll be doing the top 10 risk avoidance techniques. Again, the afternoon session. So and I've redesigned that as well. So as most of you know, most of my classes I've redone them each time before we go online. So so we're talking about member benefits, and we're talking about member benefits from SDAR. And so so today the top 6 disclosures, but I do want to show you that, and I'm very happy. I'm very proud. SDAR has put our webinars back online again. So they weren't there for a couple of weeks. There were some transitions that were going on, but if you look here, you can see that we are doing the top 6 disclosures today from 10 until 12, and then there's my property management forms, and then coming up in Thursday we've got the zip forms, and then we've got the top 10 risk avoidance techniques. So I'm very happy to tell you that we've got everything back online again. And thank you so much. I don't know who did it, but I think it might be Tracy. Thank you, Tracy. So anyway, very excited about that. Thank you so very much. We are going to spend a little bit of time today talking about actually launching into the zip forms project, and because I want to show you these live, and there's a reason why I want to show these to you, but why I want to show them to you live. But let's go back in and just cover a couple of bookkeeping formalities. I say, you know, I really want to be sure that these are in my file, okay? And I say that because, you know, I've been management, God knows, for the last 30 years of my career, and again in several states. And I can tell you there's some things that I just really want to have in my file. And so, and there's a lot of reasons. So I always ask the question, why even disclose anything? And the reason is that in California, our laws say that it is a caveat vendor, which stands for seller beware, versus a caveat emptor, which stands for buyer beware. So in California, we must disclose everything, okay? And so, you know, let's talk about the Easton case. Easton's a famous case. I just want to mention it briefly here. Let's just talk about it for a second, but I've got everything all pulled up for you. So this is the Easton case, and a fascinating lawsuit, and it occurred, you know, obviously the decision was back in 1984, but it was the plaintiff, of course, the buyer, because it's almost always the buyer that sues, right? So the plaintiff buyer sued the seller as well as the real estate brokers. And this case went up to the appellate level. So in other words, there was a decision at the lower level, and then somebody wasn't happy with that, so they kicked it up to the appellate level. Enough so that we're talking about a lot of money. Okay, so once you get to the appellate level, it's a lot of money. A lot of them don't go any farther up to the Supremes, and part of that reason is that it's just too expensive, or as we say, it's prohibitively expensive. So this was just a great case. But you know, again, and I'm not going to read the whole case to you. Obviously, it's fairly lengthy. It's 16 pages long, but there was a judgment. The brokerage lost at the lower level on a negligence charge, and they were only one of 6 defendants in the action, which was brought for fraud and negligence in the sale of the property. And so the bottom line was that the property had some slippery slopes. There was a pool, there were cracks, there's all kinds of stuff that went on. The seller was aware of it. The broker should have said something about it. And that takes us to where we are today, which is now you have disclosure obligations by law. And so this is the California Department of Real Estate's website. And this is their holding on transfer and financing of real property. And so section number 1 discusses disclosures required of a seller and or a real estate broker agent. So the Easton case really changed a lot of the way we were doing things. The actual lawsuit occurred in 1977, 1978. But here we are today, 50 years later, and we are still dealing with that. And we're going to deal with that, and it's not going to go away, I don't believe. And in Virginia, where I also teach, it's the opposite. In Virginia, it's just best you don't say anything. And so, you know, we were doing a transaction here in California with an agent who was a licensee in Virginia, and now is doing her first transaction in California. And she had I guess the benefit or the pleasure of having me as the seller's agent. and she made a comment. She said, it's just remarkable the differences between the two states. And I said, well, it's even deeper than that. And so, we want to try, and our goal is to try to protect all the parties, but it's usually the buyer is going to be the one that suffers if they're not aware of something about the property when they're purchasing it. So I just wanted to make you aware of that. This is a great little section of information: disclosures upon transfer of real property. And again, I'm not going to read it to you because it's fairly lengthy, but again, if you want copies of this, send me an email. I'm more than happy to send it to you. There's all kinds of great stuff going on in there. So we have our TDS law, and that is covered. Obviously, it hasn't changed a whole lot. Not a whole lot since 2020, but there's been some stuff that I do want to tell you about, some substituted disclosure requirements and things like that. But this is a great little Q&A put together by the California Association of Realtors, and specifically it talks about the TDS. Well, I love the TDS. The TDS is just a great source of revenue for me. Not getting this form done right or being cavalier about it is going to just get you into all kinds of trouble. So it's so anyway, again, I will send this to you as well if you're interested in it. And then finally, we have the new laws that have to do with the TDS, and this just occurred. So the new law says that disclosures required by the TDS law. Now, again, the TDS law is California Civil Code 1102.3. Okay, and it's sequitur, as we say, which means and following. And so there are multiple laws that are impacted by the what we refer to as the TDS law. So the TDS law that is in effect on the date the parties enter into the contract is going to be the law of that transaction. So apply to that sales transaction. So, and currently we have those laws. And again, if you look, you can see that I'm happy to give you these laws, but they are going to be the laws that will be in effect when you do your transaction. Now, if the laws change, and they change before you start the transaction, then you're still covered. We kind of call it grandfathered. You're still covered by the laws that were in effect at the time that when you opened the transaction. The later law would apply to later transactions. And so any subsequent changes to the TDS law after the parties entered a sales contract will not apply to that contract unless the statute specifies otherwise. And so sometimes we have that where it's like we're going to unwind it and we're going to, we want it to go retroactive, so backwards. The latter, by the way, additional disclosures are going to be our NHD. We're going to talk about that. We're going to talk about the Melrose. We're going to talk about industrial zoning and all of these things. And so, those are pretty important too. So just be aware that it is a multifaceted law. Then we also have TDS and smoke detectors. And so what are the seller's obligations in those? And so this is actually a pretty good piece. This one here discusses, it's only 2 pages long, but it discusses the fact that the smoke detector and of course the water heater bracing and all that are going to be already included in the transfer disclosure statement. I have transaction coordinators, I have all kinds of people still sending me things asking me for the old smoke detector water heater statements of compliance when in fact they're already included in the documents. So just want to make note of that. And again, happy to send this to you. And then finally, we'll talk about the substituted disclosures when we get to it. I don't want to give us too much to talk about here right now. So let's go ahead. We're going to go back to the PowerPoint itself. And who we've got? Hey, Roman, welcome. Good to see you. We're going to go back to the PowerPoint. And so again, we talked about Easton case, famous case. It's certainly one that changed the landscape for us. I'm not going to talk about the field case this trip, but that's because it really covers things like statutes of limitations on Civil Code 2079, which is only partially what we're talking about today. So we've talked about the law. I showed you the law. I also showed you the Department of Real Estate's position on it. And so we've done all that. So always be sure that you are using the current versions of the form. I can't tell you how important that is, okay? And so I always say, look at the headers, look at the footers. So when you're doing your transaction, and I get this all the time, I'm going to open up, here we go. We're going to open up the Zip Forms program, I'm actually in our templates. So we have templates. We do everything by template. And the reason is because when we update the forms, like we did back in June, on June the 27th, at about 1:30 in the afternoon, I know I kept hitting refresh. I was just dying for the new forms to come out. But when we update the forms, we'll put all of the forms, all the new ones, all the revised ones in the library. Okay. And so, but when we update those forms, we also update your templates. And that's important to know. And I'm going to tell you what you also want to be careful about. So we're going to update your template. So I create templates for everything. Okay. So I have a template for the top 6 disclosures. I have a template for the RPA. I've got a template for open house safety, because we have forms in there that get updated, like the PVOH form and things like that, the property management template, the lease templates, the seller listing, the buyer offer, all of these are all template driven for us. So at least in our office, that's what we do. So if you have them in your template, if you have things in your template, CAR will update your template. So they will put in the newest versions of the forms. And so they will not touch a transaction that you have in progress. So this says don't copy transactions, or if you do copy transactions, then make sure you have a template that you can apply to it that will make all the forms in it current. And folks, we have this. I'm a practitioner like you. I write an offer for a buyer. It doesn't come together. And then 2 months later and a forms revision later, the buyer is ready to write an offer on a second property. And at that point, I really like what I did on the first one. I don't want to have to change their names and do all that. So I will copy it. I will not ever overwrite anything. Never do that. Never overwrite on a transaction. I will copy the transaction, and then I will go ahead and I will apply the template. Because why? Because I know my template is current. After the forms revision, I know that they're going to revise the forms. Okay, so my template should be good. I don't need to start over every time I do a real estate transaction, especially when I start over with a client that has done, I call them repeat offenders. I've got one client that's done 23 transactions with me. So, do I want to keep creating everything from scratch? Probably not. I can go ahead and reuse the previous transaction, but then apply the template. Now, I'll tell you a caveat on that, because, we teach the buyer representation agreement, and I can tell you that the old form was called the BRE form, the buyer representation exclusive form. Last year, we updated that form, and now it's called the buyer representation and broker compensation agreement. And I think I'm doing that again next week. I know everybody watches what I'm doing, even the other instructors, and it's just because I just research the heck out of these things. I really do. So in the process of the template, we had the BRE, but since they did not revise the BRE, they created the new BRBC. They did not revise the BRE. So I had to add the BRBC to that template, to the buyer offer template. So they literally wiped out the BRE. It wasn't in my template anymore, but I knew enough, because I knew what the new forms were, again, based on the new forms classes that I teach. And you see over on the left-hand side, you see CAR new and revised forms. And so when I teach the class, I know that they're always going to be current. So that's what's so important about that. And so again, I'm in my template program right now. I'm going to open up top 6 disclosures, because we're going to talk about these disclosures now. And I put them in the order that we're going to talk about them, and I'm going to pull them up live for you, but I wanted to at least set the stage for what it was that we were going to be doing. Is everybody okay with that? Does anybody have any questions? Anything I can help you with? When I say look at the headers and look at the footers, so when I pull up the transaction itself, when I look over here and I see the real estate transfer disclosure statement, and I'm going to pull that one up just really fast just to show you what I'm talking about. When I go into the TDS, I look up here at the top and I see 623. Okay, so if I'm starting a transaction after June, at June the 27th, then I'm going to want to make sure I have the current TDS. Now, I wouldn't go changing it. If you've already had people sign the TDS, let's say you started your transaction on June the 10th, and the seller has already signed the TDS, and the buyer has already signed the TDS, I probably, think twice about it. Check with your broker. I'm always going to tell you check with your broker, but think about whether or not you want to update the TDS to the newest version. I would prefer in our office that we do, and we do in our offices, we use the most current versions of the forms. Okay, and so and why? Because the forms are written to protect us as well as protect our clients, as well as protect our brokers. So the forms are there for a reason, and so we want to make sure we're using the current version. And again, those current versions are a result of litigation and legislation. So we want to make sure that we're doing that. So up here at the top, I see 623. When I go down to the bottom of page 1, I see 623 again. So if I'm doing a real estate transaction obviously you're not using the form before it becomes available, but let's say I'm doing a transaction in November of 23, and the seller's agent provides me with a TDS that is dated from December of 21. Well, I'm going to ask them to use the more current version. Okay, and this is why I'm telling you that. All right, and so again, if you want, I can send you the the new and the revised forms, the links to all those. They're actually also in my newsletter. So if you're getting my newsletter, just click on the link and that'll take you to all of that. But the bottom line being, you want to make sure you're using current forms. So we're not quite at the TDS yet. I just was using that as probably a very good example, but you got to look at the headers. You got to look at the footers. Okay. All right. So we're going to start off with the most, and then my little thingy is gone. Where did it go? I said, let's take a look. Oh, okay. No, I got it. Sorry. So we're going to start off with the disclosure regarding real estate agency relationship. Notice there's no S on the end of it, even though the RPA still has an S on the end of it in paragraph number 2, which just kind of makes me crazy. But I'm sure that the attorneys at CAR are laughing because they know I catch stuff like that. But okay, they haven't fixed it yet. Then we're going to talk about the real estate transfer disclosure statement, which I think, so first of all, number 1 is clearly number 1. Okay, before you do anything else in any real estate transaction, you must disclose the concept of agency. And we'll talk about that. All right. Number 2, the transfer disclosure statement, that's the big daddy of all of them. If I'm going to have to suffer an action from anybody, the agency disclosure will get me in trouble with the Department of Real Estate faster than anything else. But the transfer disclosure statement is going to get us in trouble when we don't complete it properly. And we're going to take a look at some of those things as well. Then we'll also talk about the addendum, because the addendum form actually modifies the TDS. I'm going to tell you that if the seller is going to modify the TDS, they need to think about that very clearly, because it may trigger some new rescission rights on the part of the buyer. Then there's the agent's visual inspection disclosure, and we're going to talk about that. I'm going to show you how to fill that form out. Then we're going to talk about the natural hazard disclosure statement, of which, by the way, we have no form, because we realized that everybody was using third-party vendors to provide natural hazard disclosure, and CAR created its own company that provides those natural hazard disclosures. So they said, you know what, we're not going to have a form because we don't really want the seller making the disclosure because or the agent, worse yet, the agent making the disclosure, because a mistake on the NHD tends to be the value of the property. So if you make a mistake and you say it's not in a zone when in fact it turns out to be in a zone, the courts are pretty much holding that you essentially buy the house back, but it's it's the cost of the property, because you can't move it out of the zone and into a safe area. So fire hardening and defensible space advisory and disclosure, we're going to talk about that, and also the Q at the bottom of that on how to fill it out. Then we'll talk about the seller property questionnaire. By the way, of these forms, the first 3 are statutory. Number 4 is contractual. Okay, so the seller property questionnaire addendum is also contractual. And then finally, the federal lead-based paint disclosure is actually a statutory form, but it's really not. It's really an EPA regulation. So the EPA regulates that there must be the disclosure of lead-based paints and property built pre-78. We're going to talk about that. By the way, that includes sales and leases. So it'll come up in our property management class later on this afternoon. All right, so a quick review of disclosures. So I just want to mention to you, so I mentioned a second ago, statutory disclosures. Statutory disclosures contain rescission rights. Okay, so the rescission goes to statute, cancellation goes to contract. So rescission rights mean put the parties back
in the position that they were in prior to the contract. That's a very powerful statement. Essentially, it says that for those of us that are just real estate agents, it means giving back their money. You really owe it to your client. If you're the seller's agent, you really owe it to your seller to have all of those disclosures done at the time of the listing. I have one right now where the agent has been trying to get the seller to complete the disclosures. They're just not doing it. And everybody thinks I'll just slap it together at the last minute, or how many times have I gotten a TDS on the 15th of the, after the transaction has been put together. The TDS is a statutory disclosure. And so getting that out at the end of the transaction is really risky. Plus now the buyer, in a lot of cases, tries to use that to renegotiate the deal. And then your seller's going to be unhappy with someone, and it's probably going to be you. So rescission rights are very powerful words, very powerful rights at law. So remember, parties may not waive a statutory right. So they can't just say, we're not going to worry about it. It's okay. We're not going to sue you, that kind of thing, right? So let's put that in writing. So contractual disclosures contain cancellation rights. All right. So maybe an opportunity for the parties to exit the contract without penalty, maybe. Okay, so let's get on to the forms here. Time's a wasting. I want to get this done, try to get you out of here before 7 o'clock tonight. Besides, I have another webinar to do at 2 o'clock. So let's talk about the disclosure regarding real estate agency relationship. And again, that's going to be CAR Form AD, okay? And that's going to be tied to Civil Code 2079. So 2079 is the civil code that just kind of covers us, right? I think in retrospect, I should have pulled up 2079 to show you, but I really don't need to. I can really just pull up the form, right? So let's go ahead. I'm going to pull up the agency disclosure form, and here it is. And so again, disclosure regarding real estate agency relationship with a P on the end of it, okay? And again, this form was updated last in December of 21, okay? So now when you're writing your offer, you'll see December of 21 on this form and on a couple of others, but then when you get down to the purchase offer, you'll see it'll say 623, okay? So that form itself was revised at that time, okay? Now, by the way, the agency disclosure form went through a couple of modifications. We updated it in October of 18, and that revision in October of 18 was where we changed the listing agent to the seller's agent, and we changed the selling agent to the buyer's agent. Okay, you see what I'm saying there? So really a big change. But again, 2079. I love 2079. I get a lot of calls on that, believe it or not. And I think, Roman, you actually asked me, was it you that asked me to do a class on agency? And I would love to do it. I don't know if I can do it in an hour, but again, my trial work is all mostly based on code of ethics and agency issues and things like that. And so we've had a staffing change. So I'm probably going to be at least another month or two before I can wiggle that one into the calendar, because that's something I really want to do. So leases in excess of a year. So now, does it hurt you to make a disclosure? And I always say the answer is, if you've got to ask, you probably should disclose. And so I'm going to do the agency disclosure in all transactions. A few years ago, we updated the law to make it so that it was required in all real estate. So including commercial, including industrial, it requires the agency disclosure form. Prior to that, it was only required in sales and rentals of residential property. Okay. All right. So again, if you want to understand 2079, this is a pretty good summary of it. Again, but this is the one form that you absolutely must have in your file. I'm aware of a brokerage that had a $66,000 commission taken away from them because the agency disclosure didn't happen until the very end of the transaction. And even though it was before closing, the Department of Real Estate said, hey, you know what, that's just not right. This needed to happen at the time of the offer, needed to happen at the time of the listing. So sometimes we got to make sure we're not passing our duty off to somebody else that not really sure what they're doing. And so in that case, the TC actually caught the mistake, but it was too late, according to the Department of Real Estate. So in looking at that, this is the summary of it, sellers and buyers' responsibilities as well. And this is the new one, as I said, that was just put together a year and a half ago. If you really want to get good at it, page 2 some of you remember, if you've been in the business for any period of time, we used to print all these documents. And so we would print, page 1, and we would throw away page 2. And why? Because there really wasn't anything for us to do on page 2. So we figured out that's not important, right? Well, I think page 2 is incredibly important. I mean, if you look at it, this is going to discuss those civil code sections that we're talking about. And so again, I was asked to proof this many years ago by the California Association of Realtors. They asked me to proof it. And you know what? The only mistake I found on the form was down here at the very bottom where Agnets was misspelled. It said Agnets. It says agents, but it said Agnets at that time. I think something simply spell check could have caught. The rest of it was good. I mean, it's just a copy of the civil code. So we just took a picture of it and put it on the back of our form. So for those of you who really want to break into it, a dual agent may not. For example, a dual agent may not, without the express written permission of the seller, disclose to the buyer, et cetera, et cetera, et cetera. Okay, so again, this is getting into the weeds, but this is my agency disclosure, and certainly the number one form. It is a license losing opportunity. That broker merely lost the commission, but they can't retain their license. So but it is a license losing opportunity, especially when you get into a situation where you're representing both the seller and the buyer, and we're going to talk about that here coming up in a short bit. Okay. Whoops, that didn't work well. There we go, seller and the buyer. Okay, everybody good with that? Anybody have any questions about the agency disclosure? The agency disclosure is a critically important document in our real estate transactions. So I always say that it is the first document that your client ever signs. The first document that you ever sign, of course, is the Realtor Acknowledgement Form. The Realtor Acknowledgement Form, the RA form, is the form that discloses the difference between a realtor and a mere licensee. And I can tell you in almost every conversation I have with the public, they're like, we didn't know that there was a difference, but there is a huge difference, right? You have to know that. Okay. All right. So that's my first form. That's the first form that the client's ever going to sign. And that's my disclosure regarding real estate agency relationship. Okay. Let's talk about the TDS. Now, we've already talked a little bit about it, but that's CAR form TDS. Again, civil code 1102. Okay, so it's actually 1102.3, and et cetera, et cetera. We've talked a little bit about that. So actually, I wanted to show you, I want to take us back to some of the things that we were looking at earlier, and this is the TDS law. But we also have a little, I should probably tell you, let's talk about the TDS exemptions first. Interestingly enough, I think there's a lot of confusion about what the exemption applies, or who the exemption applies to. And they've got some good forms on all this. And again, please, I'll send all this to you. Happy to do it. But I did a transaction recently where the broker claimed that the seller was TDS exempt. Of course, the seller didn't have any idea that they were TDS exempt, but the broker said, well, they're a trust, so they're TDS exempt. That's not the case. Okay, all trusts are not necessarily exempt. All right, so when I go through here, I can look, and I'm going to try to find it really fast so we don't have to spend a lot of time on it. We're going to get more information, so that was pretty helpless. All right, okay, so I'm not finding it at first blush, but they refer to other documents where you can go ahead and look up the rest of that information. But just because somebody holds property in trust doesn't necessarily mean that they're exempt. I mean, if they've lived in the property, they grew up in the property, those kinds of things are probably not going to be exempt. Here's the issue. The issue is that you and I are not qualified to tell the client whether or not they're exempt. And so in our situation, we were the buyer's agent, and the seller's agent was insisting that the seller was TDS exempt. And so I asked to get a copy of the letter from the attorney that said that they were exempt, and I ended up getting a picture of a magazine article. And so, at that point, we'd gone back and forth for over a week, and I had just pretty much had enough. So file off to the DRE, let them take a look at it. But the exemption is not what people think it is sometimes. And so once again, we do have the quick guide for that. You can go to that and take a look. And one of the points they make in this article is that it doesn't exempt the agent, even if the seller is exempt, even if they're exempt, and rarely are they exempt. So, for example, people think that banks are exempt. Banks are not exempt. a foreclosing bank is exempt, right? But we are never exempt. But a foreclosing bank, a bank that buys properties from a foreclosing bank is not exempt, right? So at the end of the day, the bank that takes the property back, as long as they don't exercise dominion and control over the property, they're probably going to be exempt. There's a famous case down in Coronado where the bank foreclosed on the property and then collected rents for a year on the property. And this was before the whole COVID stuff, was going on. And so they were held not to be exempt in a underwater groundwater contamination issue. So just be aware the decision as to whether or not the seller is exempt is not yours to make. It has to be made by I would have it made by an attorney, clearly a document from the seller that says that. And in our case, we realized the seller had no idea that their agent was telling us that they were TDS exempt. And later on, they gave us a lot of the stuff that we were asking for in the first place. So anyway, we'll let them deal with that. So anyway, that's my TDS exempt status. Let's pull up my TDS because, again, as I said earlier, one of my favorite forms. All right, so certainly the second hot button for us. And again, you want to make sure that you use the current version. So make sure you're using the 623 version in your transactions moving forward. Whoops, I just realized I don't have lights on. Okay, you can see me okay. All right, so there have been some changes. Obviously, we've added this property as a duplex, triplex, or fourplex. A TDS is required for all units. This TDS is for all units or individual units, because individual units might require different disclosures. They might have things unique to each one. All right, and so I want to see the situated in the city of, the county of, and I want the address of the property. And again, not the legal description. I just taught a class in Virginia over the weekend where the they make a big thing out of the fact that we use the street address of the property for purposes of contract, but it is not the legal address of the property. It's not the legal description. It's a whole different thing. So I just want to see the street address. Okay. All right. And then on the date. So this date here would be the date that the seller is making the enclosed disclosure. So remember, again, going back to what we had before, where this document here says that whatever TDS law is in effect at the time that the parties enter into the purchase agreement, that will be the law that applies to the TDS. So again, if you have changes, then and they occur during your transaction, you just keep going on forward with what you were doing. Okay, everybody all right with that? The kicker is when I get down to coordination with other disclosure forms. And so here we have this used to only have two lines in it, the inspection reports and the additional inspection reports. Those are the only two lines that we had. But the legislative body got together and said, you know what, nobody's ever checking any of the boxes, so we're not really even sure that they're reading it. So we're going to come up with something else. We're going to say, we're going to talk about a substituted disclosure, and CAR has done a really nice Q&A on that. What did I do? There you go. So in section 1 of the TDS, we added an additional section. And again, I'll send this to you. Just send me an email. But essentially, yeah, there you go. The TDS came in effect in '87. Certainly right about the time that the Easton case came about. But here is no substitute. Why was no substituted disclosures for this transfer added? And again, this was added in 2019. It was AB 892. They added that language in there. So very, very important to remember that the TDS not complete if section 1 was left blank, even if there were no substituted disclosures in the transaction. All right. So to accommodate that, the language no substituted disclosures was added to that section. Okay. And so again, this goes into, is the NHD is not considered a substituted disclosure, things like that. Okay. And so again, happy to send this to you. Let's go back and get into the document itself. Notice that is grayed out, which means you are not to fill that out. You don't have the ability to fill it out. Editable by seller number 1, it says here. So when you send this via the common electronic signature platforms, the seller will have the ability to fill it out. Now, here's my advice. My non-legal advice is, and this is something that the Department of Real Estate I'm sure will echo, and that is you really need to be with the client when they're filling it out, because your job is to advise and counsel. But a lot of times, a lot of the cases that I get, the defense of the real estate agent was, I sent it over to them and I told them if they had any questions, they should call me. That is not a good defense. Okay. You sat down with them, you went over the form with them. I don't think this is something you can do in 2 minutes. And again, I teach this in my law class, and I can tell you it's much more complicated than we think. If you don't check one of these 3 boxes, then if the seller doesn't check one of those 3 boxes, then it becomes a defective TDS. And as you remember from the state real estate exam, you've got 2 years to sue. The buyer has 2 years to sue on a defective TDS. So in that Q&A that I just showed you a second ago, you'll see that in most cases, the seller would check no substituted disclosures. But again, your job is not to tell them what to check and what not to check. Your job is there to answer questions and go over the form with them. Okay. All right. Section number 2 talks about those items that, the seller is or is not occupying the property. And then finally, what items are included in the transfer. I always tell the seller, if you're taking it with you, don't check the box, but make sure you take it with you, right? But if you're leaving it there, then check the box, because you're going to be asked the question later on, are any of the above, the best to your seller's knowledge, any of the above that are not in operating condition? And so this is very important, right? I get the TDS a lot of times where yes or no is not checked. So I've sent it back. I say, you want me to give this to the buyer? I'm happy to do it. I'm going to do it anyway, but you want your seller to complete the TDS. And so I'll frequently send these back to the seller's agent saying, maybe you want to finish up with the seller. Okay. All right. So that's any of the above that are not operating. Then I get to the top of page 2, and now I'm any significant defects or malfunctions in any of the following, yes or no. And if the answer is yes to any of these, to the previous question, to under A, or in this part, anything that says yes, I want to see you write out an explanation for it. Okay, it doesn't have to be incredibly important. It doesn't have to be, it doesn't have to be it needs to be a description, not a diagnosis. That's what I always say. Disclose, don't diagnose. Okay, so that's what we do here. The seller does all this. They describe it. If they need additional sheets, they can go to additional sheets. And there we go. We're off to the races. Okay, so all right, carbon monoxide devices are devices mentioned in here. One of the reasons we don't need that anymore. Water conserving plumbing fixtures only applies on property built before 1994 anyway. But again, I get a lot of people sending me requests for those. Paragraph number C, I've never seen completed properly. I normally, if I get them back, if the seller has filled this out by printing it, I usually get that pen mark down the right-hand side that says no to everything. Okay, and so it's like, it can't possibly be. We added the word mold years ago, decades ago. We added the word mold, so you could not answer no to section C1. But I still get no. And so, the reason we added it there was because we really don't know what mold is. But the question is always going to be, are you aware? And so this theme, by the way, is going to carry over to our SPQ and our SPQA. Okay, so again, I'm looking at my time here. I want to make sure we get everything. So paragraph number 1, substances, materials, or products which may be environmental hazards, because California is big on environmental hazards. Radon gas, lead-based paint, any of these kinds of things. Features of the property shared in common with adjoining landowners. Encroachments, easements. I personally think that 2 has to be yes, because I'm sure you have a fence in between you. Who owns it? We don't know. 3, I think, has to be yes, because all properties have easements, right? 4 and 5 open for discussion. Did you do room additions or anything without necessary permits? But they could have been done better than the permits, right? But we don't know. But question number 5 has to do with whether or not they weren't in compliance with building codes at the time that they were done. Okay, so these are disclosures that need to be used. I find often plaintiff's counsel will match the TDS with the lawsuit, and a lot of times they'll say things like, "Well, you answered this, you answered no to question number 4, when in fact you actually knew something completely different. So you lied on a statutory form, and then we're off to the races." Okay. Fill, any settling, flooding, drainage, major damage to the property from 3 of the 4 required disclosures, right? We have 2 fire, 2 flood, 2 earthquake, and of course landslides comes from the Easton case, but fire, flood, and earthquake are in our natural hazard disclosure. So again, if the seller says no, I'm not aware, but the NHD says yes, that doesn't create that doesn't necessarily create a rescission right based on the TDS, but it would under the NHD. So zoning violations, non-conforming uses, neighborhood noises. I don't know if a property doesn't have noises or other nuisances. CC&Rs. So again, not just homeowners associations. All parties have deed restrictions. My property, I've got a tiny little house in Del Mar that's about 800 square feet. And I know for a fact I can't build a 16-story high rise there. The city of Del Mar probably have some problems with that. I mean, my neighbor, they gave him a hard time, gave him a ticket for repaving the little section of driveway right immediately in front of the property. Driveway, the garage is in an alley, and it's like, how did you ever even see that? So it just is what it is. HOA, if any, common areas, if any, notices of abatement or citations, if any. Again, all this yes or no. Lawsuits, buyer against the seller, those kinds of things, yes or no, give me the answers. And if you've got to go to more, then I'm going to tell you, you need to be thinking about that ADM form, okay? All right, underneath here's my satisfaction of the smoke detector, that the seller certifies that at closing it will be compliant, right? And then also the water heater tank bracing is also included there. And those are both health and safety code, 2 different health and safety codes. Seller signs it. We've managed to make it so that the seller could sign page 2 again, rather than bleeding into page 3. That was a problem we had for a long time, was when we did one of the revisions to the TDS. It made it so that the seller was signing at the top of page 3, so essentially not signing underneath their disclosure. Page 3 once again belongs to us. So we've got section number 3, which is this is one of my favorite things. I don't know a real estate attorney that can't quote this language off the top of their head. Reasonably competent and diligent visual inspection of the accessible areas of the property. Okay, so again, read the Easton case. In our office, our agents check the AVID form. I would recommend that's probably a really good idea. And then they sign it. And then the buyer's agent, when we get to section 4, when we send this over to the buyer's agent completes their portion here, whatever their broker's instructing them to do. The mistake I frequently see is in paragraph number 5, where people are signing here before the buyer's agent signs up or fills out their part up here. It's inappropriate, right? Because down here you're saying I've got a copy of the above, when in fact the buyer's agent comes in later, fills in this part above, right, over a signature, which, as we know, could be fraud, right? So you definitely don't want to have, and a lot of electronic signature platforms we're automatically having sellers sign them at the time of the listing, and the seller's agent signing at the time of the listing. And a lot of times the agent will say, well, we just did it to get it over with. Well, no, you're not getting it over with, because it says up here that you've got a copy of the inspection up here, the buyer's agent's response. Is everybody good with that? Anybody have any questions about the TDS? I love the TDS. It's one of those things that can get me out of trouble, can get me into trouble, whichever. Okay, let's talk about the addendum really quick. Why? Because we have an addendum at CAR. We've got the addendum, which we modified for use with the TDS. So right here, I've checked the box, transfer disclosure statement. Okay, so that's in our addendum. It's in your normal addendum, your ADM form. And again, we added that language actually in 12 of 21. So an amendment to the TDS may give the buyer a right to rescind. Again, that's a legal decision, certainly not one that you and I want to take lightly, but we want to probably get all the disclosures done at the time of the listing, so that when the offer comes in, and I should have shown you that in the bottom of page 3 of the TDS, let's take a look at that, because it says right there, 1102.3 provides a buyer a right to rescind a contract for at least 3 days after delivery of this disclosure. if the delivery occurs after the signing of the offer to purchase. So after the buyer and the seller come together on it, this is why we send the TDS with all the other statutory disclosures over to the buyer at the time of the counter offer. Okay. So again, real estate broker is qualified to advise you on real estate. If you want legal advice, you definitely need to talk to somebody other than us, right? So people ask me all the time, they call me up and they ask me for legal advice. I say, yeah, you know what? I'm probably the one guy who knows better than anybody where that line is, and I'm not going to get close to it. Okay. So there's my TDS, very important. If the seller wants to continue their disclosures, this is a great form to do that on. And then we're going to have the buyer sign it at the appropriate time. Okay. So again, I want to have that done at or about the time I take the listing so that I'm not doing a hurry up and then trying to get all this stuff completed and out at, taking too long. So again, that's CAR form ADM. Let's talk about the Avid. The Avid form, I really like the Avid form. I think it's the coolest form, right? And it comes from Civil Code 2079. And I'll never forget, I was in a meeting with the district manager for the Department of Real Estate, and she said, it's the only thing we ask you to do. And I got to think, I kind of like that. Anytime Veronica says anything, I write it down. Seriously, that was October of 18. So I wrote it down, but it was like, oh yeah, I get it. Okay. It's not the only thing that we do, but it is, one of those things that we really need to be afraid of. Okay. So in the old days, if you remember the TDS, here's what we were having. We were having people write on the TDS. And they were putting in here, they were checking the box and they were putting recommend physical inspection by licensed contractor. I just had a transaction a couple of months ago that the broker did that. And I'm like, really? I mean, God, we stopped doing that about 20, 25 years ago, right? Recommend physical inspection by licensed contractor. I mean, that's, so when I'm in court, the judge says to me, why did the agent shirk their 2079 duty of inspecting the property? And I don't know what to tell you, right? So again, I don't know, courts trust me. So, but I clearly never going to check agent notes, no items for disclosure. I'm always going to have the Avid in there. I like the Avid because it serves to jog our memories of things. Page one, not a whole lot to do. Okay. I want to make sure all this information at the top is accurate. And then I want to make sure my company's information is accurate in there as well. And again, since my TDS can be for residential 1 to 4, so single family home, a duplex, a triplex, or a fourplex, same thing holds true for an Avid for each of the units. Or if they're all identical, then Avid for one. I don't know how you would do that. I think they need a separate one for each one. But again, make sure that your company name follows in here properly, okay? So lots of really good disclosure stuff in the Avid form. I really think, folks, it's one of those forms, I really think you should read it. I know a lot of us, we just get things signed just because we're told to sign them because we want to get our check and go to Cabo for a couple of weeks, do whatever. God, I haven't been to Cabo since 85. So, I like what I do, right? But, listen, I'm going to read the form and I'm going to tell you something. This form, more than probably any other form, when we're defending the brokerage, we're going to have this, the attorney, defense counsel, the attorney for the broker is going to have this up on the wall in 10-inch letters for the jury to see, because this says a lot of really good stuff. And part of my favorite thing is, so right here, California law does not require the agent to inspect the following, and that is areas that are not reasonably and normally accessible. Okay, so I don't have an obligation to pick locks. Okay, areas off-site, condominium, no. Public records or permits, please don't do that. But I to this day, I still have real estate agents that go out and pull permits on properties. Listen, the seller needs to pay for that, or the buyer needs to pay for that. You need to not do that, right? Just like you probably wouldn't be doing the inspection on behalf of the physical inspector that the buyer hired, okay? And then again, common areas of planned units, et cetera, et cetera. So lots of discussion of the agent's limitations. If you haven't read it, then how do you know you're not doing something inconsistent with what it says? And so the document was prepared to protect you, but then when you make statements or you do things that are contrary to the document, you get yourself in all kinds of trouble. It's not worth it. This paragraph down here at the bottom, what this means to you, I can't tell you how many times I've had a buyer, again, it's the buyer who sues, where the buyer says, well, I figured that the seller's duty to disclose and the agent's duty to inspect would satisfy my duty to do, my investigation of the property. And so this paragraph itself is really clear about that. And again, I've seen this one up on the board. I always like sitting in the booth, next to the judge when that one shows up, because I'm going like, boy, this is going to be a lifesaver right here. I love working with attorneys that understand real estate law, right? We call them the QCREA, the Qualified California Real Estate Attorney. And so, they pump this up on the board. Agent's inspection not intended to take the place of any other type of inspection, nor is it a substitute for complete and full disclosure by the seller. So we're going to distance ourselves from everybody, right? Regardless of what my inspection reveals or what the seller discloses, California law specifies the buyer has a duty to exercise reasonable care to protect themselves. And so that case that I was referring to, we want it handily. I mean, I'm always the relief pitcher, right? I mentioned the other day that I'm the Trevor Hoffman, but then somebody told me that Trevor Hoffman hasn't been pitching for the Padres for 20 years. So anyway, I'm always the one that comes in at the end. But again, folks, this is so important. If you haven't read it, then how are you going to make sure that you're not making statements inconsistent with it? We always worry about people coming after us in a real estate transaction, but we always have the ability to protect ourselves. And so a lot of these forms are going to do just that. All right. Okay. Page 2. I need to see this top part figured out. 2 and 3 are the only parts where we really interact with it. Okay. And then I've got room by room. So it has us go room to room. So Veronica made a comment in a meeting that in that same meeting, she said, you need to be able to defend the fact that you did your inspection. And so this is a great way to do that, right? You took the time to fill out the form. We're going to assume you did it right. Certainly up here where it says weather conditions, if you put in clear skies and then plaintiff's counsel looks up the weather for that day, because over here on the left is the date and time, and it was raining cats and dogs, then you're going to have some issues. So that's what plaintiff's counsel is looking for. All right. So in here, if I have a room that doesn't apply, I may put NA in there. But if I have a room that I didn't notice anything in it, I'm probably going to put nothing noted. And then when I get, but if I get to a room that has something, I'm going to want to make sure that I disclose, I don't diagnose. So I want to disclose what I saw, because up here at the top again, reasonably competent, diligent visual inspection of the accessible areas of the property, right? And so again, I don't have to climb up through attics or crawl spaces underneath property or anything like that. I don't have to go crazy, okay? I can maintain decor, right? But at the end of the day, when I do it, if I see something, I'm going to tell you what I see. I'm not going to tell you how to fix it. I'm not going to tell you why it is the way that it is. The door sticks, all you got to do is lift the handle up and pull the door open. No, sometimes agents think they're protecting themselves by doing that. No, you're really going beyond it. I would just say door sticks, right? So, don't say because of the paint or anything like that. Don't get into that. You need to keep it pretty brief. In our office, our agents send us their avid for review. And so a lot of times I will edit the avid to make sure that we're saying it the way it should be said. Okay. And then bedrooms and bathrooms and all that kind of stuff. We got away from calling it the master bedroom. I mean, that's a trend nationally now. Now we're calling it the primary bedroom, that kind of thing. Okay. Everybody good with that? It's really important. Page 2, very important. Page 2 is the inside of the property. Page 3 is the outside of the property, okay? And it's the last page. And so we're going to do the same stuff. So down here under garage or parking, crack and slab, right? I'm going to have that on almost every single one of my avids. Why? Because all driveways have cracks in them. I don't think I've ever seen a driveway that didn't have a crack in it. So I'm going to say cracks noted. I'm not going to say normal. I'm not going to say common, not settling crack, not it's nothing. I'm not going to make statements like that because I'm not qualified to do that. I'm held to the standard of education required for me to get my license, not as a contractor. So I'm going to say cracks noted, and that's the end of it. All right. But I see some of the craziest things in some of these forms. And actually, I look at them because I get a good laugh out of it. Okay. So then we get the little box down here. This disclosure is based on again, look at this. How many times do you have to see this on the same form? Right? So this is telling you something. This came out of Easton, okay? So firm who performed the inspection. So this can be used by the seller's agent as well as the buyer's agent. But the one that the DRE is looks at is who performed the inspection. So the person that signs it better be the one that performed the inspection, because the DRE has said, we think it's fraud when you did the inspection, but then you took it back to the office and your boss signed it as if they did it. Your boss signed it, and the boss didn't do the inspection. And so we think that's fraud. When the Department of Real Estate says fraud, I'm out of here. I got to go get ice cream cones, something. I just don't want to hang around for that conversation. I obviously listen to everything that they say because it's really, really important. But when they start talking about fraud, they're coming to get you. Okay. And so, again, give me a call. I'm happy to help you in any way that I can. And then more disclaimers. This is all fairly new. We're not, excuse me, not home inspectors or contractors. Buyers should obtain advice about inspections of the property. So remember that recommend physical inspection by a licensed contractor. Well, this is language written by the lawyers. I'd rather have that language. Okay. All right. If the buyer fails to do so, you're acting against the advice of the broker. All right, we're telling you to have someone else investigate the property for you, or do it yourself, but you're taking the responsibility for it. Buyer signs it. You notice there's no place for the seller to sign it. The seller only initials, and that's just initialing a copy of the disclosure that the seller's agent observed or the buyer's agent observed, and then the rest of them fill out this part. So I see a lot of times the seller's agent signing here underneath the acknowledgement from the buyer, but yet it says we have received a copy of the disclosure, but you don't have a copy with the buyer's signature on it. So I'm probably going to have a problem with that. Okay. So folks, listen, trust me, make it a big deal, do this thing the right way. Okay. All right, good. Avid. Anybody have any questions about the Avid? Did I have anything up here? No, other than, by the way, it does show up in the commissioner's regulations about the buyer's agent inspecting the property. Remember, the seller's duty is to disclose what they knew or should have known. The buyer's duty is to investigate. The agent's duty is to conduct a reasonably competent, diligent visual inspection of accessible areas of the property. There you go. Got it memorized. Okay. All right, good. Okay, that's my Avid. All right. The TDS is not complete until the seller's agent delivers their Avid to the buyer. All right. You got to remember that because that's the new rule. The new rule says that until the sellers, so why would the seller's agent not do their inspection at the time that they took the listing? Why not? Right? I think that the seller's agent should take the time to do that inspection of the property at that time. They can always amend it later, but none of this, I'll wait until we get an offer and then I'll do it. That's just not going to fly. Okay. You need to set up a system of doing business, and the Department of Real Estate looks at systems. Do you have a system in place for how you do things? So in our office, we require our agents to do their Avid at the time they take the listing. When they write the offer, they need to do their Avid right away. Okay, and again, I always say when the physical inspector goes right, you go left. You never want their report to be a substitute for yours. You need to be completely independent. Put a set of earmuffs on and do your own inspection of the property. Okay, all right. So remember that point down here, because when you send over when you're the seller's agent, you send over the TDS. You need to send your Avid with it. Okay, otherwise it's an incomplete TDS. Okay, everybody with me? All right. Let's talk about the NHD. Okay, NHD, Natural Hazard Disclosure, came about in 1998. I'll never forget it. The original forms, and I'm going to show you, there is no CAR form, by the way. I said this earlier. We eliminated the forms, and part of the reason was because nobody was using it. I mean, literally, that's what the attorney said. They said nobody was using it. So they figured it out because we track. Actually, SDAR does, CAR does. We track the usage of the forms. So like at SDAR, the mold advisory is our most commonly used form. I would have thought it had been the LAD, but it's not. It's actually the mold advisory. So we actually keep data on what forms are being used in a real estate transaction. Okay, so the NHD, it's the law. It's a statutory requirement. 3-day right of rescission if you give it to the buyer, electronically, 5 days if by mail, all the other stuff applies. Okay, so that NHD is a big deal. All right. Again, there is no such form, but that is Civil Code 1103.7. So Civil Code 1102.3 was my TDS. Now I've got Civil Code 1103.7, something else I get to deal with. But something else that I just don't think is that complicated. Okay, so I'm going to pull up the the NHD, just realizing, did I do? Oh yeah, I did do one. Okay, here we go. So here's my NHD, and I thank you to whatever company this was that provided this. I asked them for a generic form, something that I could just use as an example. You can see it's 89 pages long. And so let's take a look. It talks about what's going to be in there. This is the one page that tells you, what they did to come up with their data. They call it their one-page report. But then the rest of the document is the explanation of what they found. Okay, so again, use them, use somebody else. It's up to you. I did have a broker. We just sold a property in Malibu, and the seller's broker said they all go to the same database. Well, that is absolutely partially correct, not completely correct. But it's not just that they may go to the same database. This particular company goes to many, many more databases, but it's the thoroughness of the report, it's the way that it's written, and it's the accuracy. Now, a lot like title insurance, I don't get, in 44 years, I don't have a lot of claims against title companies, but I don't want to be the one claim. So so make sure that whatever vendor you're using, make sure that they are good at what they do. Okay. All right. Look them up, see what kind of claims they have. So we're going to talk about this property. And again, this is the natural hazard disclosure statement. By the way, very different than the one that came out in 1998. I remember when it came out, and I remember that the CAR had a coronary about it because on that document it said the agent said had the agent saying that they certified that the information that the seller was providing was correct. Well, we don't have any way of knowing, and certainly even today, we wouldn't want to do anything like that, right? We don't do that. We have an obligation as the seller's agent to tell the seller of their obligation to make the disclosure, but then as the buyer's agent, we merely have the obligation to provide them with the report. There's nowhere at this part of the document with the statutory disclosure, no part for the buyer's agent to sign it. Okay, so we look at our zones, we look at special flood hazard area. This property is, again, as we said before, 2 fire, 2 flood, 2 earthquake. And so the first 2 here are flooding, and it's not in either one of those, right? And then, but under fire, I've got yes for a very high fire hazard severity zone, okay? And so based on the local jurisdiction's determination, AB 38 disclosure form is voluntary. So now you're going to see this get beefed up because we're pursuing legislation right now to have the natural hazard disclosure companies, who are the ones with the best access to the data, do even more disclosures. And so I know that with I was chair of risk management last year, and I had the pleasure of sitting next to Gov Hutchinson for a year. And some of the conversations that we were having, people would just go, "Whoa, that's really deep." Well, and Gov very kindly got up in front of the group once, and he said the first time he said, "I'm just really glad we have a lawyer here who understands what we're actually doing on risk management." So not that anybody else didn't, it was just that our conversation was obviously very different. So it was a high point of my career to be chair of that committee. But anyway, so I've got a very high fire hazard severity, so we know that's going to trigger a bunch of stuff. So the answer is yes. The second one, it doesn't fall into, but I'm already going to want to take a look at that form that we'll talk about in just a minute, the FHDS form. Okay. And then earthquake, it's earthquake fault zone, no. Seismic hazard zone map not yet released by the state. I think I find that to be the most common answer there. I don't know anybody knows what a liquefaction zone is, but it's a fascinating thing. I covered that in my hazardous materials management class, my graduate class. But soil liquefaction zones are fascinating. Pacific Beach, San Francisco, Fisherman's Wharf, some parts of Oceanside, where essentially a really good shaker, and then buildings are just going to start to subside into the ground. And it's based on the soil conditions and the water level and all that kind of stuff. And so it's a fascinating concept. Interestingly enough, in the Agua Prieta earthquake of was it Agua or Loma Prieta, the San Francisco earthquake during the World Series back in '86. God, I never watched baseball. I was watching the beginning of that game, and Al Michaels is talking. I'll never forget it. And then all of a sudden, everything starts going like this. I'm like, something really bad is happening right now. And of course, my phone lights up. People are saying, hey, they just had a huge earthquake in San Francisco. I said, yeah, I kind of saw that start. And they said, how's that going to affect property values? And I said, probably for about 15 minutes. Right. And I was right. You couldn't touch a property today for what you could have bought it for back then. But soil liquefaction, Fisherman's Wharf, that was what caused all the fires. It wasn't the gas lines erupting from the water heaters or anything. It was the soil liquefaction. They were dipping down in, rupturing the gas lines because they put the gas pipes in the concrete. Okay, so all right, so there's my brief soliloquy on that. Who do we have in here? Hi, Stephanie. Okay, so again, my obligation is for the seller to sign because they're making the disclosure, right? Then the seller's agent must sign, and then we have the required language that says that we're having a third-party vendor do this, and then we get down to the bottom and we have the signature of the buyer. No signature by the buyer's agent. The obligation for the buyer's agent is merely to relay the form to the buyer. Okay, everybody good? So why would you send this form? Again, I know it's the same form. I know we have the light test. I know, we're signing in counterpart. Linda's going to say, well, I thought you said we could sign in counterpart. And the answer is yes, but I don't sign things underneath a blank line. So just one of those legal things just makes me crazy. So seller's going to sign it first, then the seller's agent, and then I'm not letting my buyer sign it until they sign it because I need them to approve the fact that it was actually there, that this was the report that was sanctioned by the seller. Okay. All right. Now this is the part where I get in trouble because now I'm going to look. So see, here's my synopsis of everything. But most of especially if you're doing TC work, that I need to get down to my environmental hazards. The nice part about this form, this company that we use, is that they also provide the environmental hazards. Their environmental hazards are required by law in all of your transactions. So, but that's not only sales, but also on rentals. But people don't realize that that's required on rentals. So I'm counseling a couple of property management companies right now, making sure that their templates, again, have all those forms in them. And I'll be talking about that this afternoon as well. So this is essentially a breakdown of the various, whoops, I think I saw what I was looking for. If it wasn't a protected document, then I would be able to, there we go. This is my fire hazard. But I'd be able to put bookmarks in it. Blah, blah, blah. Really good website for finding out about home hardening, fire hardening, and then where is it? Stephanie, help me out. What page? I'm heading for. Obviously, these are all explanations of the stuff you're reading up the top. That's why they call it the one-page report is here's the answers, and then we're going to explain it later. Okay, all right. A lot of these disclosures in here are statutory. They're required by law. I've had complaints from other natural hazard disclosure companies that say that some companies raise the bar for the rest of them, and I'm kind of happy about that. But frankly, it's good. I want to make sure. I know that Pete Selecki, our attorney at Prudential, and then later on counsel for SDAR, said that they can't sue you for what you tell them. So I agree with them 100%. So I'm looking for my environmental. I want to spend a lot more time doing this, but I know it's down near the bottom. It's the part that gets missed a lot of times. So if you get a report that actually has the signature pages, make sure that you have your client sign the signature pages, but not before they actually have received a copy of the report. Okay. Okay, here we go. This is the NHD again. Again, my signature page would have been up at the top. And then down here, AB, so subject property is not located in the California Department of Forestry and Fire Protection's official very high fires zone, but you could provide an AB 38. This is something that they weren't doing before. They're clearly doing now. And then if they have to make those disclosures, they fill out these. Now the NHD company's not gonna be able to fill this out because they're not gonna know anything about the eaves or soffits or anything like that. Okay. And then the rest of the form, the AB 38 form, and then we're going to get into the official version that we look at. And here's my what I was looking for was my energy rating booklet, need to have them sign that. And then finally, my earthquake risk disclosure statement. They need to fill that out if the property's built prior to 1960, right? So 60 for earthquake, 78 for lead-based paint, et cetera, et cetera. Okay. Did not see my environmental hazard part of there. All right. So that being said, let's go back over. So that was, whoops, wrong one. Sorry, folks. Backwards. There we go. Okay. So that was my NHD. But now let's talk about my fire hardening and defensible space advisory and disclosure. And again, that's the FHDS form, and that is tied to Civil Code 1102. It's actually 1102.19, but I didn't put that in there just in case they changed it on me. So let's go back over here, and I'm going to go to my fire hardening form. And here we go. So this is the beautiful part about this form. And I remember sitting next to Gov, or actually I was standing because I was talking to the group and he was sitting, because he always waits till I'm done and then he gets up there and just kills it. So and he even said to me, he said, you know, I said, so is this going to be the final version of this form? And he said, And I go, okay, I get it, right? So they're constantly working on this to try to satisfy the legislative intent, all right? But let's take a look at the form. And I noticed that in number 1, doesn't even apply. Now, I want to know that before I do anything else. Okay, so now as a general rule of thumb, we're going to look at this really quick, but down here at the bottom of the page, oh, look at that. A defensible space decision tree. So this is a purpose is that, remember, it's a statutory form, folks. So you don't want to be telling you don't want to be filling it in for the seller. Okay, so but this is going to help the seller in determining. Now, I think this should be more interactive. Like if they check no, I think that it should check no on the form, but it doesn't. Not at this point. I think part of that is because they don't know if there are going to be any more revisions made to it. But let's go back up to the first part and look at applicability. So we have 2 major sections. We've got the home fire hardening, and then we have the defensible space. And on the home fire hardening, paragraph number 2, this is paragraph number 2, all right, is only required for sellers of residential properties, not commercial, residential, if it's a 1 to 4, which by definition is residential, right? Civil Code says, resident 1102 says residential 1 to 4. If the seller is required to complete a TDS, okay, now so you remember that transaction I was telling you about where supposedly the seller was TDS exempt. I don't think they were, but so now they're going to be breaking another law. Okay, all right. So the property is located in either a high or very high fire hazard severity zone, number 3, and number 4, the improvements were constructed prior to 2010. So if it's after 2010, don't worry about it. But if all 4 conditions are met, then you got to figure out fill out paragraph number 2. Okay, 2B specifically. 2A, there's nothing really to fill out. I think there's a really good website that everybody should go to visit, readyforwildfire.org. And you can actually type in the address of the property to see if it's in the zone. So notice you as the agent cannot fill this out. We want the seller to fill it out. Now, I don't know. I have sellers say, well, what's an Eve? I don't know. I thought it was Adam and Eve. I don't know. What's a soffit? I don't know. I really don't. I don't know what a soffit is. I know what roof ventilation looks like, right? So, but that's my answer to whether or not I have to fill out number 2 is whether or not A qualifies. The second one, B, defensible space. So the requirements specified in 3 are only required. So that's the next paragraph down here. 3, okay, is only required if residential 1 to 4, seller is required to complete a TDS. So 3 of the 4 things from up top, the property is located in that zone. If any of the 3 is not met, you don't have to fill out paragraph number 3. Okay, so we got rid of the date, the January 10th of 2010. And so there's only 3 things now. Up here, you could kill it with the property being built, in 2017, right? But the date won't apply to B. They got to do defensible space. Okay, if it applies, all right? And so then that's when they would fill this all out in here. And again, this is where we go into all the happiness about whether or not you're going to try to make the buyer responsible for it. And here's some of the problems we have with that. If you have the buyer be responsible for it, then and the buyer signs off on it, and then they find out they got a year to be in compliance, right? And then they find out that it's going to be $10,000 if it can even be complied with. They're coming after you. All right, so I don't like having buyers being asked to pay for something that they don't know what it is, much like we got rid of the WPA form because sellers were signing it, agreeing to do pest work when they didn't know how much it was going to cost them. Okay. All right. So that's the point behind that form. I don't want to spend a lot more time on it, but there's a lot of things in here. And I do get a lot of calls from agents. I did an hour class on this, and we just really don't have time right now to do an hour class on it. So all right, so that's my fire hardening and defensible space advisory and disclosure. Let's talk about my seller property questionnaire. So once again, not a statutory form, so it doesn't have rescission rights, but it is a contractual form. So it does have cancellation, potentially has cancellation rights to it. Okay, and again, while that may not sound like a big deal, it really does. It is really a big deal to determine the manner in which the client can exit the transaction. So here's my seller property questionnaire, and it was written by the state of California, the California Association of Realtors Attorneys. It was essentially a copy of the SAD form that SDAR had created at their risk management committee. That was the seller's additional disclosures form, because we just knew the TDS wasn't going to cut it, right? There wasn't enough stuff in there, and to this day there isn't enough stuff in there. Other statutory disclosures like death on the property, things like that are not included in the TDS. So the TDS we just know is deficient, but we're okay with that. We created the SAD, CAR copied it and created the SPQ. Great job on it. It's a great form for use statewide. And then SDAR created a form that would append this one, not replace this one, but append it for properties located in San Diego County. Okay, so again, not a substitute. You have to have all three. This form is not a substitute for the TDS. Okay, it is to go along with the TDS. If the seller is exempt from completing the TDS, we still think they should complete the exempt seller disclosure form, which if you look down through here, you're going to find that essentially this is the paragraph number 6 is the ESD, right? The exempt seller disclosure. So you would do the ESD form if the seller was TDS exempt, because they're still required by statute to make those disclosures, right? But the only exemption really is that they're not required to use the form, the TDS form. That's all. They still have to disclose what they knew or should have known about the property. Okay, so this is my SPQ. Lots of really good language in here. Again, I suggest you at least read the first part of it, right? Go through that. I'm not going to read it to you. I mean, tell the buyer about no material or significant items affecting the value or desirability of the property, right? What's the purpose? Seller awareness. We actually finally now talk about what that awareness means. Are you, the seller, aware of any of the following? And so documents, within the last 3 years, death of an occupant of the property upon the property. Okay, so I was just doing a class on Sunday where we were talking about Heaven's Gate. 40 people killed themselves in this house in Rancho Santa Fe 20 years ago, and so the buyer comes along, buys the house for a third of what they were asking for it, levels the house. Does that get rid of their obligation to disclose the death on the property? And I'm going to say no, because it says the death of the property on the property. Okay, so in other words, anywhere on the property, I don't care, bedroom number 2, I don't care, they died on the property, then you have to make the disclosure. And I particularly think that Heaven's Gate is a heinous act, much like the Sharon Tate murders, where I think that disclosure is probably going to carry with the sales for quite some time. Okay, so anyway, here's all the rest of the stuff. I cannot believe it was 2-hour presentations. We'll get done on time, but I'm not going to go over. So anyway, so more stuff in here. Methamphetamines, of course. Is it an industrial use zone? Is there a nuisance from that zone? Are you within a mile of a state ordinance location, former federal or state ordinance, so like Coronado or Tierra Santa or something like that? Okay. All right. And those are the statutory disclosures. Insurance claim affecting the property within the past 5 years. Okay. So then repairs and alterations, structural, all of these are the seller, you the seller, aware of any of these things. So again, these are all meant to dig deeper into the deficiencies in the transfer disclosure statement. Okay, and so and again, I'm sympathetic to the fact that how long do you want the TDS to really be? I just don't think it's complete. I don't think it covers everything. I think everybody would agree with me on that. Anything else in here? Again, this is 4 pages to append the 3-page document. Okay, so anybody have any questions about any of this? Again, I'm not going to stop on it, but if you ask a question, I will. Cannabis, a big issue now. Obviously, California law conflicts with federal law. So, but that's not your place to discuss that. So seller signs it after completing it, the buyer signs it, and of course the seller and the buyer both initial each of the pages. Okay. Anybody have any questions about any of that? Seeing none, let's talk about the addendum. And again, I mentioned this earlier, again, not a statutory form. It is in every offer that we write in San Diego County. If we're writing an offer in San Francisco, we're probably not going to include the form. But when we write an offer in San Diego County, we want the seller to provide that form. And so let's go ahead. We're going to take a look at the form real quick. I'm going to pull that up here. So again, the beautiful part about this is remember, we started off with the TDS, and then I always put the SPQ next to the TDS. Then I put the SPQA next to the SPQ. Why? Because the 3 of them should all talk to each other. They should all flow one to the other. And as you can see, the way that this form is written by the attorneys at SDAR, there's a lot of it that they just said, we don't really need to do anything. So they do SPQ5, which was fairly new addition. They lined everything up. So obviously, paragraphs 1 through 4 were fine on the SPQ. Okay, so this is referring to the SPQ. The paragraphs below are numbered to assist you in comparing it to the SPQ. So obviously, we don't need to be the Department of Redundancy department. So nothing to say really in 5. 6, nothing really to talk about. It was done fine. But then in 7, we get into repairs and alterations, give us copies of things. In 8, structural systems and appliances. And then we get down to some of these other things that were started in the SPQ but not finished. And again, then we get to paragraph number 9, a couple of things in there that we felt needed to be added to it. 10, everything was fine. 11, everything was fine. 12, we got a couple extra questions to ask. So you see what I'm saying? We're just going to start, drilling in, unpeeling the onion, as I call it, to make sure that we cover everything that needs to be covered. And again, so the San Diego Association's Risk Management Committee is held by attorneys, real estate attorneys who can only get in there with invitation, but it is the very learned people that are talking about that. And then they added all this that they felt needed to have further clarification. So Bob Muir and Jackie Oliver and Jason Murphy and a bunch of the other attorneys that are on there, they come up with all of this stuff here. Ann Throckmorton, who's not an attorney, but certainly past president of SDAR, still very active in the association, has a lot of input on that. Title, ownership, and legal claims, neighborhood, governmental, other additional information. So again, the seller will complete this when you email it to the seller. All of these fields, in fact, that was my task, was to make sure that all of these fields were able to be completed by the seller. And so again, obviously the buyer initials as we're going along. And then the buyer signs it at the bottom of the page. Okay, I really don't understand why we need a date next to it, but I think the date next to the signature is probably sufficient. But who am I? So that's my seller property questionnaire addendum. Okay, again, my TDS, then the SPQ, then the SPQA. Okay, everybody good? Let's go to. Okay, I'm sorry. It is the standard of care in San Diego County. I had an attorney call me the other day who was defending a brokerage, and he said the agent did not use the SPQA. And I went, ugh. And they said, I know, before I had a chance to say anything, they said, I know it's the standard of care in San Diego County. And it is. It is the standard of care, whether you're a member of San Diego Association or not. It is still the standard of care. So again, we're going to provide the form. If the seller's agent doesn't provide it, we're going to want that because we want to protect our buyer. But that was the last I heard from that particular attorney, but I'm sure that, that probably my reaction to it was that's going to be a tough one. But again, a lot of us say, are we just being lazy? I mean, what's the story? I've got transactions that I try to start. The agent says, we're not going to provide that form for you. It's like, well, why not? Well, because, we don't have that. We're not required to. Okay, well, you're not required to, but if you don't do it, you could be getting yourself into trouble. Okay. So lead-based paint. Let's talk about lead-based paint. So lead-based paint and lead-based paint hazards disclosure, again, acknowledgement and addendum. This is going to apply to pre-1978 housing sales, leases, or rentals. And so remember that it's not just sales, and it's all properties built prior to 1978. So I have people call me up and they say, well, properties built in 1978 in February of 1978, do I need to do lead-based paint? And I say, well, I think the rule says pre-78. So I'm going to tell you, obviously that's not a pre-78, but again, if the seller is aware of lead-based paint, I would probably make the disclosure. But again, that's just, how I roll on these things. So it is an EPA regulation. It's not and I assure you, the EPA, when they issue a regulation, it's a lot easier for them, right? Because they don't have to go to the legislative body and get them approved and stuff like that. But when we've got an EPA regulation, they can move around a lot easier. It's kind of like the Department of Real Estate regulation. They'll do a lot of their stuff to enforce the law, but they can create regulations. They can move a lot faster than what would happen with a state agency having to approve of something. So it is 42 U.S. Code 4852D. And again, one of my favorite things. So let's go ahead. Let's take a look at that form really quick. The lead paint disclosure form. There it is. I want to make a note too, though, by the way. Remember, your environmental hazards material is all required in your transactions. If you're using certain natural hazard disclosure companies, they will make the environmental hazards disclosures for you. But remember, if you're doing leases, you need to be getting that form yourself. So what I'm going to do is I'm going to go up here where it says all forms. So this is what we refer to as the library, and I'm going to search for environmental. So I'm just going to type in ENV, and of course that's going to give me the commercial form. I'm sorry, I'm in the wrong one. So let's go down. Where am I going to be? Here we go. We're going to go down to EPUBs. So folks, you see right here, EPUBs. I'm going to click on EPUBs, and then I've got my environmental, and it's one of 6. So I'm going to get rid of that. It's number 1, number 2, number 3, number 4, number 5, number 6. Now they moved them up to the top of the queue, and I'm really glad that they did. But these are all forms that are also required in all of your transactions that a lot of people don't know that they are. It doesn't hit my top 6 list, but it certainly are going to be important forms. So residential hazards, protecting your family from lead in the home. So whether it's built pre-78 or not, you need to have that form in front of the buyer. Home energy rating pamphlet. Again, we saw a lot of this in the natural hazard disclosure discussion, but again, earthquake hazard report if applicable, and then the signature page. It's a very large document. I would recommend that you send the document in separately from all the rest of the documents. If you try to include all these with the other disclosures, it's not going to go through. So I would send the 6 of these independently, and then I would have the seller then and the buyer sign and the agent sign the homeowner's guide, the signature page itself. Okay, is everybody good with that? I want to make sure I brought that up. It's under EPUBs. All right. So again, I'll talk more about it in our class this afternoon if you're going to make it to that one. That's the property management forms class. So okay, again, this form was recently revised as well, based on EPA, but we added sales, leases, or rentals. So you got to make sure you're doing that. So the lead paint, again, this is the lead-based paint and lead-based paint hazards disclosure, acknowledgement, and addendum. So it becomes part of the contract. And then I'll let you read all that. Housing built before 78 may contain lead-based paint. But the newest addition is, of course, the renovation rule. So the renovation, repair, and painting rule says that contractors and maintenance professionals working in pre-78 housing, childcare facilities, and schools with lead-based paint be certified. And so that means no self-help on that. their employees be trained. They follow protective work practice standards. The rule applies to renovation, repair, or painting activities more than 6 square feet of lead-based paint in a room. So right here, more than 6 square feet, or more than 20 square feet of lead-based paint on the exterior. So I was selling my mother's property. She passed away a couple of years ago now, and the property was built in 1970. Again, I don't tell people something has lead-based paint in it. I don't tell people it has asbestos in it because I am qualified, but I tell them I'm not qualified to make that decision. They're going to have to go ahead and have somebody run a sample on it. And so anyway, we've got, you know, the cottage cheese in the ceiling going on, and this is Scottsdale, Arizona, by the way. Individual walks into the house and says, you know, I'll take all that, you know, cottage cheese off of the ceiling for you. And I said, you know, it's probably got asbestos in it. And he says, well, he says, we're all going to die anyway. And I thought, yeah, but I'm not here to hasten that process, right? And so I was just so shocked about that response. And I felt terrible. Needless to say, I did not hire him to do any of the work because it's not just him, right? It's now you made the asbestos friable. You know, it's moving around the house. It's 10 microns in size. It gets down into your lungs. It could cause asbestosis. And so, you know, I've known people who've died from it. It's not a for sure killer, but you're for sure going to be uncomfortable. Lead-based paint, same kind of thing. I'm just not going to mess with that. And if you know, I hate to tell you ahead of time, you know, I went to the YouTube and pulled up a video on the effects of lead-based paint on children, and it is heartbreaking. It is permanent. It is irreversible brain damage, and it's a very sweet tasting thing. Not that I would know personally, but very sweet tasting, and so children are drawn to it. And so that's one of the reasons why this rule is so very, very important. Okay, so again, enforcement of the rule is well underway. 13 years now. And you should go to the EPA's website and look that up. So seller or the housing providers. So the housing provider is our new term for landlord. Disclosure, we have no knowledge of lead-based paint or anything else like that. So this, I never see these filled out. I never see NA. I never see anything in there. I'm looking forward to the day when I see somebody actually complete it, and maybe it's just so much as like NA or no or something like that. But I never see anybody fill it out. We tend to have our clients sign the form without it really being completed, and that part really bothers me. So we have no reports or records. No NA, yeah, no, not that I'm aware of, whatever. I've never seen anything in here. But if you leave it blank, I don't think that satisfies the obligation. Okay. So anyway, we have to give them a copy that protect your, we just talked about this, right? Protect your family from lead in the home, Homeowner's Guide to Environmental Hazards and Earthquake Safety. I just showed you where those were up in the library. For sale transaction, the buyer's got 10 days, which, by the way, they can minimize. They're allowed by law to have one done, but this is one of those things that they can waive it early. But only for the rental, or I'm sorry, only for the sale, not for a rental. Okay, so the seller certifies, review the information and certifies that the information provided is true and correct. And then again, make sure my date is consistent with the date that the form is completed. Seller's agent or the housing provider signs. And then is the buyer going to waive the right to conduct the risk assessment? And if not, is it okay if they just don't do it? You know, are they negligent in not doing it? Are they going to come back after you and say that you didn't remind me? You know, things like that. So be aware. Buyer, tenant, sign it here, and then of course the cooperating agent, which I prefer that language. The cooperating agent versus the buyer's agent would sign here. Okay, and again, I mentioned this earlier. It's 42 U.S. Code 4852D. But lead-based paint is a very big deal, folks. Definitely, if the property is built pre-78, I would not close. Certainly, I would do this in the beginning. This would be one of the things that I would send over with that counter offer. I did a transaction in Lake Forest, and I met, it was my seller. The seller was a former student of mine at one of the colleges that I was teaching at. And he says, I knew when we sold our house that we wanted to have you represent us. And so I sat down with the seller for 3.5 hours and we filled out every single disclosure. And so it included a death on the property within the year. It included unpermitted additions in the property. When the buyer came in with the offer, we sent them all of the disclosures along with the counter offer. The buyer says, I've never seen anybody do that. And I said, well, we're kind of required to do it, really. It's just most agents don't think to do it, but we're required. I mean, we have to make those disclosures up front. But you understand that you may not have a right to rescind the contract now based on all the disclosures. I mean, we sent them everything: natural hazard disclosure, TDSs, everything. And the buyer's comment was, that, well, I asked for a 30-day escrow, but I really don't need it now because you've told me everything. And so they literally closed it in 13 days. I mean, it was great. I'm buying the car, I got the RV going on, the whole thing. But, at the end of the day, send all those disclosures over with the counter offer. The buyer, a lot of times the buyer doesn't realize it. And I always tell the buyer's agent, you understand they may not have a right to rescind the contract. So, I don't say they have no right because I can't give them that. It's legal advice. Okay. All right. So that's my lead-based paint. That's a big deal. Okay. So that's a really big deal. Let's talk about honorable mention. I wanted to talk about a couple of things. And first of all is my possible representation of more than one buyer or seller. It's just so funny how whenever I do a webinar, my phone rings off the hook. It's like, and they know I'm doing a webinar. So anyway, okay, so let's talk about my PRBS form. And again, that's a CAR form. It's attached to your template when you write an offer. It's attached to your template when you take a listing. I do want to talk about it, and here's why. Because this is the form that allows you to do dual agency. All right. So remember, my agency disclosure form discussed the concept of agency. It discussed what it looked like, what single agency was. When I take a listing, I know I'm the agent for the seller, but I don't know when an offer comes in, if it's somebody else underneath our broker, Linda, then I might be in dual agency. Well, in some states where I teach, the agent has to get consent from the buyer again. They all do buyer representation agreements, but the buyer representation, the law in Virginia, for example, and by the way, the law, it is a law effective July 1st that you must use the buyer representation agreement. July of last year, must use the buyer representation agreement or you don't get paid. If the buyer writes an offer on a property, if it's my buyer and they're writing an offer on a property listed by myself or my broker, then I have an obligation to go to the buyer to get them to get additional consent. Well, in California, we do that up front, which is kind of nice. I like that. And that's what this form is. But I've seen people who have, rather than having all these forms done, because they don't want to scare the buyer, especially because your contract's got 16 pages to it, is that they'll print all this and then they'll take the form out. Well, this is the form that the buyer authorizes you to do dual agency. So, and this is both for the buyer and the seller authorizing you to do that. Okay. And so CAR, acting ahead of the curve, right? We're anticipating the issue, created this form. So again, multiple buyers, multiple sellers, everybody needs to understand we might be representing other people, but dual agency for sure. If the seller is represented by the broker, seller acknowledged broker may represent prospective buyers of seller's property and consents to the broker acting as a dual agent for both the seller and the buyer. So you're getting that consent up front. So I mentioned Virginia. So in Virginia, if the buyer doesn't have to consent. So if, all of a sudden you find out that, where you were the single agent and now you're all of a sudden getting into dual agency in Virginia, the buyer can say, no, I just see it as an inherent conflict of interest. You ask any lawyer in California, any real estate lawyer, they're probably going to say the same thing. I can't get my head around the fact that how you can't, disclose conflicted information to the parties. But this is the form that allows you to do that. And in Virginia, again, you have a separate form that has to get signed at the time that you become aware of the dual agency. And again, the buyer can say, no, I'm sorry, you've been showing me property for 6 months, but I'm just not comfortable with you writing the offer, you representing me. So they have an additional legal fiction over there called designated agency, where the broker can say, well, fine, you're the agent for the buyer, you're the agent for the seller. So it's really just kind of like the emperor's new clothes, right? Or the romper room mirror or something like that. It's not really real, but it's clearly dual agency. But so anyway, be aware of that. We added language into it that offers are not necessarily confidential. We came about this, I remember probably about 15 years ago. We effective January of 2008. Yeah, right about 15 years ago. So January 2008, NAR changed its code of ethics to allow the seller's agent to discuss the content and terms of competing offers with competing buyers. So that was a whole departure, because it used to be, in the old days, it used to be where I can't tell you what the other offers are. I'll lose my license for that. Well, but NAR said, wait a minute, that might be a great advantage to the seller if the seller's agent is allowed to disclose the content and terms and use those to work the offer up, right? And so, what a unique concept. And again, I come from that time when we would never tell anybody how much the other offers are. Today, I tell them, I say, okay, here's the deal. NAR said I can do it, and I'm going to do it. So be aware that I'm going to probably be using that in a multiple offer situation to get the seller more money. Anybody have any questions about any of that? I always use that as an excuse to get a drink of water. Okay. Anything else in there that jumps out at me? No. Okay. So again, I like the form, but you got to use. If you don't use the form, then you're going to have to get it before you start representing in a dual agency situation. Okay. So that one was an honorable mention. I wanted to bring that one up. Let's talk about the local area disclosures. And again, that's SDAR form LAD. Now, I personally love the LAD. And why? Because it makes me look really good. First of all, because we have disclosures that are necessary in the San Diego area that aren't necessarily found in other areas. And so CAR and NAR, I walk into a meeting, or usually risk management meeting or zip forms meeting. Again, I'm on the Lone Wolf Advisory Committee, but they use this as an example of what local associations should be doing for their membership. And it just makes me all proud. I walk in, I go, yeah, I'm that guy, right? But the LAD is an amazing form, and it's really come a long ways. And I truly believe that it is where the grid came from on the current purchase agreement. So let's just take a look at it really quick. I'm not going to read it to you, but obviously, I think it's a good read. I really do. I think it's an easy one to read. Again, Bob Muir, just an awesome real estate attorney operating out of San Diego, and I like Bob. He's very bright. But he put together, all the pictures and stuff are done by the marketing department, obviously, but Bob is responsible, him and a small task force responsible for actually the creation of the form and not the creation necessarily. That goes back to Bill Williams, who was an attorney on our committee as well, many years. Bill, oh God, now why can't I remember his name now? Darn it. Anyway, he created the original LAD. Bob Muir picked it up and has been revising it ever since. So, but that SBSA form had was the original start into the grid pattern, and then the LAD followed it, and then of course CAR did it with the RPA. Oh, you should have heard them complain. And people complaining right and left about that grid. It's just going to confuse people. And the lawyers all said, now they're not going to go anywhere past page 3. They'll stop there, and the rest of it's really where they want to be. And at the end of the day, it hasn't had nearly the frightful circumstances around it that everybody thought it would have. So looking at that, we see that the LAD's got some disclosures in it, and the disclaimer at the bottom, it's produced by, and it's been doing this since, for 20 years. I think it's a really good form. We use this in every transaction. We put this on paragraph 4B, where we want the APA, the LAD, and the SPQA all to be included in the transaction. And so, I just don't know why you would do a transaction in San Diego County without it. Notice the revision date, they just revised it. I know that's a real task because they're trying to get it revised at every 2 years. But here's my table of contents page. And again, so I've got general disclosures over here on the left. I've got environmental disclosures next, traffic, roads and transportation, air traffic and airport disclosures, specific areas disclosures. So I've got my coastal, I've got my North County inland, I've got my East County, my San Diego City, my South County, and then finally the signature page. And so again, each area has its own unique stuff going on. Tijuana International Airport, trolley lines, whatever. Tierra Santa has issues with unexploded ordnance, as does Coronado, things like that. So certainly an excellent form. I don't think, I know this is it's a fairly lengthy form, but I think it makes really good reading. So what do real estate agents do? They just send it to their client and say, here, sign it. I really think, it's 16 pages of happiness. I know there's a lot of stuff in real estate that you've got to do that maybe you don't want to spend the time doing, or maybe you haven't read it yet. But excuse me, I think that this is all designed to protect you. And as I said in the beginning of our webinar, I've had enough court cases where the agent said, I sent it over to the client and told them if they had any questions, they could just let me know. But you left it up to your client to read it. You left it up to your client to fill it out, to complete your TDS. But I see it all the time. And so I can tell you it's not a winning defense. So lots of breakdowns in here of all the stuff that's going on. And I like the fact that they're humble enough to say, if you see anything that is not in here, it should be, then let us know. And I don't think they don't do that on every page, but just some of the pages. So defective drywall, hazardous materials, lead hazard inspections, all this stuff. So you can see that there's something for everybody. I would recommend that you at least read through it at some point, make sure you got a pretty good idea what it says, because it is, again, created to protect you. And I assure you, they spend a year on updating it. So it's a very intense, a lot of work goes into this. When your client says, well, I didn't know that sea levels rise, and you go, wait a minute, that's part of, paragraph 1 under coastal. It's B. I knew I saw it someplace. So, are you going to memorize all this? Probably not. Hotel Del Coronado, for those of you doing business in Coronado, City of Coronado has approved a master plan for expansion of the Hotel Del. Construction is definitely active. They're selling units there. So, there's some really good stuff in here. I really think you should spend some time looking at it. All right. Okay. Let's see here. I mean, did you know that City of Oceanside is building a 170,000 square foot arena that'll host more than 6,000 fans for sporting events and the San Diego Stalkers? I mean, this is like reading a really good newspaper article. I don't read that much news anymore because I'm not confident with the sources, but that's fine. But look at all this. I mean, we've got Rancho Bernardo, groundwater problems, methane gas, Poway Unified School District. So this is something you really should spend some time looking at, and we're not going to spend much more time on it. But after all of that, we did not have them initial all the pages, but we do ask them to sign the signature page. And so please don't only send the signature page. Make sure that they've got the entire document, because again, it is 16 pages of happiness. Okay. All right. That being said, let me see, where are we here? That's it. Thank you for joining us. Does anybody have any questions about anything that we've talked about here today? I know it's a lot of material. I don't even know what time it is. We're getting close to quitting time here, almost noon. Does anybody have any questions about anything we've talked about? I get constantly asked from people, where can I find your webinars? And so I tell you, we've got a YouTube website. Get your QR code reader ready. Here it is. Just take your QR code reader on your phone, take a picture of that. It'll take you right straight to the website. I load them all up there. I just loaded up another 10 of them. You can also go to @Burke Real Estate Consultants Inc. Obviously no .com on the end of it. That'll get you there. Then we have a bit.ly link. I've learned how to create all these things. And by the way, because my RPA class has been approved by the Department of Real Estate for 5 hours of continuing education credit. So they said I needed to have a place for people to go to see the form. So we don't have the form up there yet because I'm waiting for SDAR to tell me when. I always give them first dibs on stuff. So tell me when they want me to teach it. But again, it'll be 5 hours of continuing education. So the bit.ly link is bit.ly/REAL-estate-ed. Case is important. So that's why it's all lowercase. And then please, if you're going to go there, please remember to like and subscribe. And so like just tells me that, you appreciate what I did. That makes me feel good. Subscribe will notify you whenever I've done an update to it. So like this webinar will be updated to the program probably this evening because it takes a while for them to take out all my bad language and stuff like that. So subscribe is a good idea too. So please like and subscribe. I would very much appreciate it. They don't pay me when you do it. That's not what that's about. But it would, I think you need to have the information. So anything else you can think of that you want that we'll talk about, SDAR, we're famous for the educational opportunities that we provide. Please let us know. I also have weekly email updates. I know Roman, I know you and Stephanie, you get those emails. Oh, Stephanie, you're not getting my emails. I got something that said that yours were bouncing and I don't know why, but anyway, if I send you an email, there's a link in there that says subscribe yourself here. And there's also a link in my email to the videos. So you can get to those anytime you want to get there. Or you can send me an email, say, please, sign me up for your newsletter. So, and the newsletter, by the way, so SDAR just got it back on the website. We had some challenges recently, but they just put it back up on the website so that you can actually go there. It's on the San Diego One page. So here they are. All the webinars are finally up there again. They haven't been there for since the beginning of the month. And of course, I'm having a heart attack about it. But we finally put all that in there. And the daytime classes, the classes at the association are done. Essentially, my classes are being done at the association by somebody else because they're live there in person. So again, I do the webinar versions of all of these things. So anyway, all that being said, does anybody have any questions about anything we've covered today? I am happy to answer them. Let me take us back to, that's right, to my email address. There you go. If there aren't any other questions, I want to thank you for being here. I very much appreciate the value of your time. I will be back this afternoon at 2 o'clock to talk about property management forms. If you know anybody that would benefit from that, again, the link's in the newsletter, or you can always have them send me an email, or they can go to the SDR website. So thank you all for being here. I very much appreciate the value of your time. And as I say, from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Have a great day. Take care for now. Bye-bye.